The next argument is in the matter of SV versus SS, appeal of SS, Richard Ducote and Victoria McIntyre. Representing appellants is attorney Richard Ducote. Representing appellee is attorney Elizabeth Pride.
Good afternoon. A family court judge presiding over a child custody case entered a gag order that restricted appellants from, among other things, directing or encouraging third parties to speak publicly or communicate about the custody case. Appellants lodged an appeal contending that the order violated their rights to free speech pursuant to the United States Constitution and the Pennsylvania Constitution. The Superior Court concluded that the gag order was constitutionally permissible, and this court is now reviewing that determination. Mr. Ducote.
Yes, good afternoon, Mr. Chief Justice and Honorable Justices of the Supreme Court. My name is Richard Ducote. I am not only appearing as counsel for SS, a prominent Pittsburgh physician, but I'm also appearing as a pro se appellant and counsel for my associate, Victoria McIntyre. It is because we are the three gagged parties in this proceeding. Neither I, my associate, or my client can, under this gag order, speak about this case publicly, communicate about the case, or encourage other people to talk about this case, or encourage other people to find out the details of this case. Now, notably, Attorney Pride, who represents the father in this case, and her client, and all the other attorneys who represented my client in the trial court have absolute, total, unbridled freedom to go on Dr. Phil, to hold a press conference, to stand on the corner, to give newspaper interviews, to do anything else. I, my associate, and my client are the only ones who can't speak about the case. Now, I want to first note that the question that the court granted this review on seems to limit the question to whether or not the prohibition against giving information that could tend to identify the child is permissible. I want to first point out that this order is much broader than that. The first sentence of the gag order that Judge Clark issued, admittedly, without any law that she could find to support it, says, "It is hereby ordered that defendant SS, Richard Ducote, Victoria McIntyre, shall not speak publicly or communicate about this case." And this Commonwealth has a history of protecting free speech more stringently than the United States Constitution does. This gag order only limits the information about the child's name to testimony before legislative bodies. When I told Judge Clark that we wanted to use this case to try and get the law changed and that we intended to testify before legislative committees, she said that was fine, but my client could not use her name. I asked her if she had to wear a bag over her head. She said,
Mr. Ducote, if you want to get the law changed, we're going to let the justices ask some questions with Justice Wecht.
Thank you.
Thank you, Chief Justice. Good afternoon, Mr. Ducote.
Good afternoon, Your Honor.
Sir, is it your position that the gag order merely restricts mother from speaking about, mother and counsel, about the case in a manner that would identify the child or allow identification of the child? Or is it your view that the order restricts all of you from speaking about the case at all, subject to a few limited exceptions?
Well, it's very clear from the language of the case in the sentence that I just read, that is the first sentence in the order, says that we cannot speak publicly or communicate about the case. So that's what it says. And we're the only ones, again, the other side can talk all they want about the case.
And so from your perspective, from a free speech, from a First Amendment perspective, as well as the Pennsylvania analog, is it your view that the principal constitutional infirmity of the gag order is its overbreadth?
Well, it certainly is overly broad. However, it's content-based, which is presumptively unconstitutional. It's a prior restraint on speech, which is presumptively unconstitutional. And the Superior Court does not engage in any significant analysis of that requirement or that test for strict scrutiny under the Constitution. One of the phrases that's used in the gag order that is clearly overly broad is we can't share information that, quote, tends to identify the child. Now, I don't know what tends to, how broad that can be interpreted, but even my client's face, she might not say her name, but, she certainly has a face and an identity, and this gag order requires her to give that up.
Thank you.
Thank you.
Justice Mundy.
Justice Mundy, move button assigned.
Sorry, I was doing Justice Fair's trick.
And I'm doing my job.
Would you be as opposed to the order on a constitutional basis if it in fact included the father and father's counsel, or would you still be here today challenging the order?
It would still be unconstitutional, but I think the fact that it does not include them points out that this is not about restricting comment about the case. It's about tending to chill criticism of the court's decision. And I think that's especially troublesome, to think that attorneys and litigants under the threat of incarceration are prohibited to discuss in the public forum disagreements that they have with court rulings is very, very worrisome.
Thank you.
Thank you.
Thank you, Justice Barrett.
I'm just as a preface, I'm curious. You said all of your clients' prior counsel. How many of them are there?
There were two other counsel.
Two other, and how long has this case been going on?
This case went on for about 3 years before the appeal.
Okay. I don't believe that this is content-based. I think it's content neutral. You can go to the legislature, you can go to the top of the mountain, and you can scream about prejudice against fathers, favoritism for mothers, splitting of siblings, abuse of children, etc. The only thing you can't do is talk about the specific case. And Judge Clark said the reason for that was she was trying to protect the child, which seems to be legitimate. How are your First Amendment rights constrained in any way, given the freedom you have to speak about everything except to do something that implicates this poor child?
Well, we can't talk about the case. That is content. There are 48,000.
It's not content, excuse me. Again, content is substance. What can you not talk? And I don't want to fight with you. What substance in this area can you not talk about because of this constraint?
Well, you can't talk about what the court did in this case. Again, we have 48,000 new custody cases in the Commonwealth every year.
I think you can, sir. You simply can't name this case. You can. Well, about any of these 48,000 cases.
For example, suppose you have a child in high school who's a star quarterback, and suddenly there's a custody change, and because of the custody change, he won't be playing for this team, and the PTA and the sports reporters want to know what happened to this particular child. Under the principle that the Superior Court sanctioned here, that child's mother or father would not be able to talk about what happened and why it happened and where the child is or anything else. Or if you have a promising 8th grade girl who's going to be in the science fair and they're looking forward to her contribution, and suddenly the custody schedule has changed and she can't participate. Nobody can talk about it. In every custody case, the argument can be made without evidence that talking about the case and discussing this particular somehow affects the child in a negative way. And once we do that, we license tyranny, in my view.
Well, again, and last question. You don't see the distinction between discussing the broad subjects, frankly, I think it's not a bad idea that the poor quarterback is not under the pressure of the public newspaper because of his parents' problems. But you don't see the distinction between discussing that issue and not personalizing it to the child.
Well, there's no context, to say that there's a problem in our court system, and you're asked the question, well, what's the evidence of that? Well, it's my case, but I can't talk about it or I'll go to jail. I think that's a very serious problem.
I understand your position. Thanks, Chief.
Thank you.
Thank you, Justice Todd.
Thank you, Chief. Counsel, I am concerned by the characterization of President Judge Clark's order. You indicated, and I'm going to give you an opportunity to correct this if I misunderstood you. I thought you indicated that the gist of her order, her motivation in entering this order, was obviously to prevent you, client, and your client's previous counsel from criticizing Judge Clark. I read it completely differently. I read it as an order entered to protect a child and to protect the child's identity, which is a worthy goal that I believe every justice on this court would endorse to some extent. So could you clarify that for me?
Certainly. And I'm not saying it's to deflect or to prevent criticism of the judge herself. She very clearly said in her ruling, I have no problem with people criticizing me. It's criticizing the decision, the analysis, the conclusion, the ruling. And that's what the criticism is. Otherwise, then nobody could talk about the case. If in fact...
From where do you draw that conclusion that the intent of the order is to prevent criticism?
The fact that it just applies to us. We're the only ones who disagree with the decision. And again, let's go back to the issue of the child's name. The Shep decision, which was the only case that the Superior Court decided, and which was decided by this case in 2006, that case did not involve people talking about the case. It involved a parent being able to discuss with his daughter what was and is a crime, that's bigamy for religious purposes. This court, interestingly enough, even though the Superior Court did not, fully discussed and revealed that 13-year-old child's name. And there have been law review articles that have been written about that case that discuss the child's name. The parents were interviewed. Parents discussed the case. It was a big. It had a lot of interest in the media and in the legal community because of the religious significance.
Let's get back to this case, though. In this case, isn't it possible that Judge Clark's order only applied to you and your client and her other counsel because you were the only ones at risk of mentioning the child's name or revealing her identification?
Well, that's prior restraint, content-based, and unconstitutional. And again, if that were the case, then why doesn't it apply to everybody? If it were in fact, look, I don't want anybody talking about this case. I don't want this child, and the child has a different name than both parents, different last names. So, once you start putting those sorts of restrictions on a parent tending to identify the child, how can my client explain why suddenly this child who was by her side and with her every day and was well known in the community suddenly disappeared from her life?
So it's your position that you and your client should be free to reveal her name, reveal the child's name whenever you'd like, and her identity.
Well, there are two issues here. Whether that's a good thing to do, and that was never done in the publicity that was given this case, the things that Judge Clark ordered us to take down from the internet, to remove from the other online social media sites, the child's name was never revealed. That was never done. So the notion that even though it was never done in the past, it can be done in the future with an additional layer put upon it that we can't even discuss the case, I think is totally unconstitutional. Nobody mentioned the child's name, but the father can. The father's attorney can. The father's attorney and her client can go and mention my client's name. We can't mention the father's name. It just doesn't make constitutional sense. Thank you.
Thank you. We have approximately 5 minutes left, so I would like to divide that time for questions between Justices Donahue and Justice Doherty, starting with Justice Donahue.
Thank you, Chief. Counsel, could Judge Clark have sealed the record in this case?
She could have, and she didn't, which is another point.
I understand that. My question to you is, could she have done that?
She could have.
Okay, and if she had done that, would she not have accomplished much of what is at issue in the order that she entered?
Well, I think there's a common misperception about what a sealed record is. A sealed record means that the public can't go to the prothonotari's office and say, I want to see this SS versus the SP versus SS record. And
it also means that you can't go to the prothonotary's website and publish that information on a website.
Well, it doesn't mean that the case can't be discussed, and that's the critical difference.
No, you're not answering my question. To the extent that she could accomplish prohibiting you from replicating information on the website and sharing it with the public, if she could have done that with a sealing order, why can't she do that with this order?
Sure, because if the record is sealed, that doesn't prohibit anybody from simply talking about what happened in the courtroom. It says that the documents perhaps can't be published or copied or replicated or disseminated, but it doesn't mean that people can't talk about what's already occurred. Can
I just quickly, because my time is limited, does Judge Clark have the authority to place limits on you as an attorney involved in pending litigation in her courtroom that are different than any restrictions that you might place on a non-attorney litigant?
Well, there was no litigation pending. This is all after the fact. So
it's an open case, is it not?
Well, nothing to do with the custody. There's nothing pending. And the only time that any court in this country has sanctioned these sort of gag orders is to prevent tainting a jury in the criminal case. No court has ever sanctioned, and there have been court decisions around the country with these sort of gag orders, and they've always been declared unconstitutional. We've cited that in our brief.
Thank you.
Thank you.
Justice Doherty, do you have a question?
Yes, just a quick question. I'd like to pick up from where you just left off, counsel. This is not a criminal case. This is a custody case in which the standard would be the best interest of the child. The child also has an expectation to the right of his or her privacy, not to have lurid or details of alleged sexual misconduct brought forth in any shape or form. The granted issue before this court is the manner that would identify the child. Share with me where you think your First Amendment right, as well as your partners and your client, supersedes that of a child's privacy in the specific contours of a custody case.
Well, first of all, if this order simply said that in the discussion of this case, the child's name shall not be revealed, then we would have a different case. But that's not what this gag order says. It says defendant SS, Richard Ducote, and Victoria McIntyre shall not speak publicly or communicate about this case. Now, there's nothing clearer than that gag order that says that we cannot talk about this case and we can't encourage other people to even find out about the case. I mean,
my question is very specific. The issue in a custody case is the best interest of the child and the child's right to privacy. Please share with me what causes your First Amendment right to trump the child's right to privacy in the determination of its best interest.
Okay, so under that hypothetical, or that question.
It's not hypothetical, so that's the question before us.
I understand. Okay, so that under that consideration, there could be a gag order from any parent talking about anything to do with their child. You couldn't tell other parents, you couldn't share with other parents that your child has a medical condition because that child has a right to privacy.
Counsel, I apologize. I would be more specific as to say this gag order was related, if I'm not mistaken, to announcements and statements made via public media and on TV stations, something that does not normally occur in some of the 4,000 custody cases that are filed within this Commonwealth, as you indicated.
Well, it's
Very specific as to your conduct and the conduct of your client. So this is, again, with regard to the case before this court, which is what you, your client, and your associate did publicly in announcing the tortuous facts of this case, which lasted in a 23-day trial. Share with me where that child's right to privacy is superseded by your right to talk about that child's private life.
The Constitution of the Commonwealth and the First Amendment of the United States of America's Constitution.
And the child's constitutional right to privacy, which is of paramount importance, takes a second seat to your right to speak. Is that what you're saying? It's a yes or no answer, counsel.
No, Your Honor, because the child's privacy and the child's name was never disclosed in any of the discussion that resulted in the gag order. It just
Thank you, Mr. Ducote.
To discuss my name and my wife's name, a majority of people would understand who my children are. You would just have to do that.
Well, if we take this to be as you're concerned, then a gag order will ensue in every child custody case saying no parent can talk at all about their child. You know, so if a child who committed suicide.
You may be
Thank you, Mr. Ducote.
It goes on public TV. Thank you, Chief.
Yeah, time is up and exceeded. So we're going to hear from Ms. Pride, counsel for the Appellee.
May it please the court, Elizabeth Pride on behalf of SB. Can you all hear me?
Yes.
Yes.
This question arises in the context of an extraordinary case in which one party is litigated excessively in every level of state court, in matters and related matters of both custody and child support, in both the state and federal courts. Millions have been spent on litigation in this case, and through it all, the appellant herein has declined to take the reasonable steps necessary to resume her relationship with the child, as outlined in the custody order of December 2016, and has voluntarily not seen or spoken to the child since. Rather, she's made a life's work of litigating and misrepresenting the voluminous evidence in this case that amply demonstrates that the abuser in this case is not the child's father, but the appellant, who has demonstrated an utter indifference to her son's well-being in her quest for attention, which has caused the trial court to step in again to protect the child from her. This is a question of whether the trial judge may limit mother's speech that is determined to be harmful and or dangerous to the well-being of the child. In an argument rife with hyperventilation and obfuscation, mother says that the court may not. Mother's argument boils down to: 1, the court owes a great deal of deference and protections to the freedom of speech. 2, any speech on a topic is content-based, thus invoking a strict scrutiny standard. 3, the court failed to provide a legal or factual justification for the restraint on speech, and that the order is not narrowly tailored to serve a significant government interest. 4, that the order was vague and overbroad. And 5, that public policy favors reversal. With regard to the first of these, the court owes a great deal of deference and protections to the freedom of speech. While mother spent more pages and citations documenting this in her brief than any other principle, there's certainly no dispute that that's true. Both the trial court and the superior court were explicitly cognizant of this fact. But no right, even a fundamental right, is unconditional. Mother's own brief acknowledges this, even as she tries to conceal it. So the question is, under what conditions may the trial court in this case place restraints on mother's right to speak about it, and do those conditions exist here? Mother does not address that question in her brief or her argument. Instead, she states and restates her conviction that her right to speak cannot be limited at all. A threshold question in this case is what level of scrutiny must be placed on the trial court's order. Mother insists that strict scrutiny applies because the speech is content-based. In getting to this conclusion, mother ignores the United States Supreme Court's definition of that term, and instead reasons that as the order's application depends entirely on the topic of speech, i.e. this custody case, there is no question that it constitutes a content-based restriction on speech. That's in her brief at 14.
Thank you. We had allowed you a brief period for state your case, which you've now done. So if you allow us, we'll proceed. Questioning beginning with Justice Weck.
Thank you, Chief Justice. Good afternoon, Ms. Pride. The question seems not to be the trial court's intentions. Those would appear to be unimpeachable or well motivated, so to speak. Nor does it Nor does the question of import seem to be mother's conduct. Let's stipulate it's been suboptimal, to say the least. The issue, I think, that's important for this court to address, and I'd like you to comment on, is the question of overbreadth. And the reason I'd like you to comment on overbreadthness is that when we decide this case, our decision will have implications statewide for all custody cases and beyond the area of custody, and not just this case where mothers behaved irresponsibly and the trial court is doing a good job. You see what I mean? The question is, if we affirm here, what is to say that it won't be the default mechanism in every acrimonious custody case, which is quite frequent, that the trial court can just enter an order saying mother and her counsel shall not speak publicly or communicate about this case, including but not limited to, et cetera, et cetera. Particularly in the day of social media, shouldn't we be troubled by the First Amendment implications of that?
The question of overbreadth, I think, goes to whether or not the order was narrowly tailored to accomplish an important governmental interest. In this case, the judge could not have been more clear that this was about the child, not about the message. The judge's order was accompanied by 19 factual findings about the potential harm to the child. And the order states that at the conclusion of the order, it states what it was not meant to do. This order does not prohibit any party or counsel from publicly speaking or expressing an opinion about the judge, including disclosing the entry of this order of court, after the information has been removed as set forth above. However, such expression shall not contain the name of the child or other information which would tend to identify the child. So the question of overbreadth, if the question is whether this order precludes too much speech, I think the court made it very clear exactly what it was trying to accomplish. It was trying to accomplish speech that might identify this child, would expose this child to undue ridicule, scorn, and scrutiny. And as the Superior Court said, the question of whether an order is overbroad is whether or not a person of ordinary intelligence can understand what they're not supposed to be doing.
Well, one of those things, if I may just briefly, because my time is short, ordering a parent, in this case mother, not to publicly state her name. That's quite a stark First Amendment issue, isn't it?
The reason that mother was asked...
I'm questioning the reasons. I don't have any reason to question the judge's reasons. Her reasons are not it's not like she's an evil genius trying to stamp out free speech in this country. The issue is what was done, not the intention behind it. And how is it that saying a person can't publicly state their name is not overbroad for First Amendment purposes?
Because the question relates to whether the judge's order was narrowly tailored to accomplish what she set out to accomplish, assuming that that was a permissible thing for her to be trying to do. In this case, given the nature of the communication, if she identified, and the nature of the facts of the case, her having identified herself tied the child to the information, to this salacious and disturbing information that mother was disseminating. So it's not a question, nobody is saying mom can't go say her name is, use her name in saying that she is part of a custody case, but she can't go out there and say, this is my name, and these are the things that my son said, and this is his forensic evaluation, and have all that stuff posted online. This was a breathtaking invasion of this child's privacy. And the thing that makes it an invasion of this child's privacy is the identification of this child. And mother's identification of herself, given that she has only one child, given the fact that she was instrumental in getting this child into his small private school where everyone knows who she is and who he is, her using her own name in connecting to this specific information that invades the child's privacy is necessary as a part of the narrowly tailored resolution to the issue that the court was trying to address.
Justice Mundy.
No questions.
Thank you, Justice Bear.
Premised upon your description in response to Justice Weck, is this case sui juris in terms of the actions taken by mother and her counsel which required the court to provide response? Or is it, or as Justice Weck suggested, is this in danger of being replicated in every custody case?
This is an extraordinary case. This case, one of the things that Father suggested here was that this court's order chills other from similar conduct. And I think that question also relates to whether this is something that courts may take as an opportunity to impose similar kinds of restraints on speech in other cases. But let's review what happened in this case. After a 23-day trial in which testified 3 psychological experts and a guardian ad litem, the results of 2 forensic evaluations were submitted. Mother continually raised escalating and fortuitously timed claims that the child had been sexually abused, and the court found that there had been no abuse by the father, but that the child's best interest would be served by being in place in father's sole legal and physical custody. And from that 23 days of trial, mother selected a short excerpt of the child's testimony and the child's second forensic interview in which he had described what he said was abuse by father.
I think I understand that because, again, our time is short here. The draft card case in the U.S. Supreme Court, I think it was O'Brien, U.S. versus O'Brien, it set forth a 4-part test if indeed the content, the speech is content neutral. Is that applicable to this case?
I think it is. The Superior Court, I believe, concluded that the higher strict standard was met by this case, but at the same time didn't reach the O'Brien factors because the higher standard of strict scrutiny had already been met. However, if you look at the standards of strict scrutiny, it's a lower standard. I do believe that it applies in this case because this is content neutral speech. This isn't about whether or not mother agrees with whether or not the court or the government agrees with what mother is saying. This is about protecting the interests of this child.
And Chief, my last question. If we find that this is content neutral, does it then follow that it's not strict scrutiny?
If we find that this is content neutral, yes, I agree that we find that it's not strict scrutiny.
Right.
I think in this case, it meets the strict scrutiny standard, but the court should impose a lower standard for a case like this.
Thank you.
Thank you, Justice Todd.
No questions, Chief.
Thank you, Justice Donahue.
No questions, Chief. Thank you.
Thank you, Justice Doherty, and we'll conclude.
No questions, Chief. Thank you.
Okay, thank you, Ms. Pride. Do you have a word or two? Although, please believe me, we understand and apprehend your argument.
I'm tempted to say more, Your Honor, but I think I will rest on my laurels.
Thank you. Thanks to.
We got it.
Thanks. We'll resume argument in the final case for the day at 2:10.
Thank you.